Good afternoon, and welcome to our current topics session for today. Today we have an exciting session on medical cannabis, prescribing laws and stigma. This has been a hot topic and highly requested over the past little bit since the laws have been changing around the country and in particular in Virginia. So today we have an excellent presenter. Juran has been employed by the Virginia Department of Health Professions since 2005 and currently serves as Executive Director of the Virginia Board of Pharmacy. Prior to her employment with the department, she practiced in long-term care and community pharmacy, held certification as a geriatric pharmacist, and served as a preceptor. Ms. Juran completed her studies at the College of William and Mary and graduated from the School of Pharmacy at the Medical College of Virginia, Virginia Commonwealth University in 1995. Ms. Juran recently served as chairman of the National Association of the Boards of Pharmacy. Please feel free to type in questions in the chat as we go along so that you don't forget them if they strike you. Caroline will address all of the questions or comments that she doesn't cover through her presentation at the end of the session. She will also be available immediately after the session for direct questions or discussion, and will share her contact information for additional follow-up beyond today. But without further ado, I'm going to turn it over to her and she will lead us in an excellent discussion. Thank you so much for joining us.
Great. Thank you so much. Hopefully everyone can see and hear me well. If not, please let me know. But certainly, again, it's a pleasure to be here. We are going to talk a little bit today about medical cannabis, the prescribing laws and stigma attached to it. And since we only have an hour in the interest of time, let's just go ahead and get started with the agenda, please. Next slide, please. So specifically, I will go over some of the legislation that's been implemented over the last several years. We'll talk about some of that rapid expansion in the medical cannabis program. We'll look at some data regarding the number of registered patients, types of approved products, monthly dispensations, prescriber recommendations, and then I'll talk briefly about an upcoming change in the regulatory oversight for the medical cannabis program that will occur January 1 of 2024. So again, we'll talk about a little bit of history, some basic regulations, and then we'll get into a little bit of data. Next slide, please. So just to do some level setting and ensure that we're all on the same page with terminology that's used in the code, THC, of course, is tetrahydrocannabinol. That's the psychoactive component of the cannabis plant. Written certification, you may all be familiar with, but that is the official form that a practitioner must use in order to recommend the use of medical cannabis. Because cannabis is still scheduled or placed in Schedule 1 federally with DEA, it is an illegal substance federally. You cannot prescribe it on a traditional prescription pad. A practitioner can only recommend the use, and under state law must use this written certification form to do so. Cannabidiol oil or CBD oil and THCA oil are the two terms that were originally used when legislation was first passed in 2015 on this subject. They were replaced in the code with a more general term, cannabis oil. We later will see legislation was passed to authorize botanical cannabis. That is the plant product that's traditionally smoked or inhaled. Cannabis product is an overarching general term that would incorporate both oil products as well as botanical cannabis products. A pharmaceutical processor, you've probably heard, certainly seen articles in the media about this, but that is the term that we assign to a facility that the Board of Pharmacy permits to be able to do three activities. They cultivate cannabis indoors for the specific purpose of producing cannabis products, and then they dispense under pharmacist supervision to patients from that location. So again, a pharmaceutical processor can do those three activities: cultivate, manufacture, and dispense the cannabis products. A cannabis dispensing facility came a little bit later in legislation. It's a term that is used legally for a facility that strictly dispenses final cannabis products. They do not cultivate or manufacture the products there. They simply, they simply dispense the products that are already produced and put into a final package form by the pharmaceutical processors. And the law authorizes 5 pharmaceutical processors in the Commonwealth, and each one of these pharmaceutical processors can have up to 5 cannabis dispensing facilities. So in a given health service area, there are 5 health service areas across the state, by the way. In a given health service area, you can have 6 dispensing sites that a patient can use. And so therefore, in total, the law authorizes 30 dispensing locations for a patient to obtain medical cannabis. Next slide, please. You can go ahead and advance to the next slide as well. We'll get into some legislation. You're going to see that every year there has been legislation to quickly advance and grow this program. It started in 2015. The Virginia General Assembly created simply an affirmative defense. So if a patient was to possess CBD oil or THCA oil specifically for the purpose of treating intractable epilepsy, and they obtained a written certification from either a neurologist or a physician trained to treat epilepsy, then they could have an affirmative defense for being in possession of these 2 oils. The General Assembly did not go so far as to authorize the cultivation or the production of these products in Virginia. It was simply an affirmative defense for possessing it in 2015. In 2016, the General Assembly did pass legislation that would authorize cultivation and production. It directed the Board of Pharmacy to have an allowance to issue up to 5 pharmaceutical processor permits, again, 1 in each health service area. It directed the board to go promulgate emergency regulations as to how it would contemplate regulating a medical cannabis program. But the General Assembly required that legislation in 2016 to be reenacted in 2017, and they wanted to review what the board was going to propose in emergency regulations to ensure that this truly was something that they wanted to go into effect. So it had to be reenacted in 2017 before the law took effect. 2017 came, the General Assembly did indeed reenact that legislation, and it did find comfort with the emergency regulations that were promulgated by the Board of Pharmacy that addressed health, safety, and security requirements for the pharmaceutical processors. We can advance to the next slide. Great, thank you so much. In 2018, we saw some additional legislation introduced. It expanded the allowance for any Virginia licensed physician to treat or alleviate symptoms of any diagnosed condition or disease determined by that physician to benefit that patient to benefit from such use. So previously, again, it was restricted to neurologists, physicians trained to treat epilepsy, only specifically for the treatment of intractable epilepsy. But that was further expanded in 2018 to allow for any physician to treat for any medical condition as determined by that practitioner. Additionally, in 2018, the board had walked a competitive application process for awarding these 5 pharmaceutical processor permits. That was a new model for us at the Department of Health Professions. We generally don't make licensed practitioners compete for their licenses. You graduate from school, you pass the required exams, we're going to give you a license. But in this instance, there were 5 coveted permits that could be awarded, and that was it. So we created a request for application. It was a very competitive process. We received 51 applications in voluminous boxes of documentation to support those applications that had to be reviewed. By December of 2018, the board had awarded 5 conditional approval permits. So the way the permitting process worked is you submitted your application. Based on those applications and a screening matrix, we awarded 5 conditional approvals. They were then given 1 year to go build their facilities based on the documentation that they provided in writing. After that 1 year, the board came out and inspected the facilities to determine, did you actually build it the way you said you were going to do so in your application. Does it comply with the physical and the security requirements of our laws and regulations? And if so, we would issue a pharmaceutical permit to that location. They could then operate, begin cultivating the cannabis. In 2019, we're now a year after the conditional approval process. So they have theoretically completed the building of their facilities, and we have gone out and inspected them. 4 of the conditional approval locations had successfully built facilities that were compliant with our laws and regulations, and they indeed were granted pharmaceutical processors and could begin operation. One of the locations had not begun constructing their facility at all. And so the board rescinded that conditional approval. And so still to this day, we only have 4 pharmaceutical processors currently operating. There is an ability in law to grant a 5th pharmaceutical processor, but we currently do not have one operating in that space quite yet. And we'll touch on that in a little bit. Additionally, in 2019, legislation was introduced that expanded the types of practitioners that could issue a written certification. Again, previously it was just physicians. Now the General Assembly had authorized nurse practitioners and physician assistants to also be able to award or issue, I should say, written certifications to patients recommending the use of medical cannabis. They also allowed for the wholesale distribution of final products between these pharmaceutical processors. They did put a restriction in place for dose concentration. This was intended to try to prevent unintended accidental overdoses, specifically by children, for instance. So again, still to this day, a single dose of a cannabis product may not have more than 10 milligrams of THC in that dose. The General Assembly last in 2019 also created a registered agent. A registered agent is an individual who can go to a cannabis dispensing location or pharmaceutical processor and obtain that cannabis product on behalf of a specific patient. So maybe this is a hospice patient or a bedridden patient. They can work with a quote unquote registered agent to go to the facility on their behalf to acquire and obtain the medical cannabis for them. Moving down to 2020, we saw additional legislation getting introduced and passed on this subject. At that point, the General Assembly removed the affirmative defense. They just said flat out, it is legal to possess CBD and THC oil in compliance with the existing laws and regulations. You no longer just simply have the affirmative defense. They did remove the 2 terms, CBD oil and THC oil, from the code and replaced it with that more general term of cannabis oil. Very significantly, they also removed the 5% THC cap on cannabis products. Prior to this, the oils could not contain more than 5% THC. So it was a low THC concentrated oil product. That's how it was sort of billed. At this point in 2020, that cap was removed. And so still to this day, there is no maximum concentration on THC in medical cannabis products. They did retain the restriction of the 10 milligram THC per dose. They also created an ability for pharmaceutical processors to acquire the oil from industrial hemp extract, which helped facilitate the production of products. They condone the authorization of telemedicine for when a practitioner works with a patient and ultimately issues a written certification. In 2020, they did allow for telemedicine for the first time in this space. At that time, the telemedicine requirements were rather stringent and had to more or less satisfy federal telemedicine requirements if you were going to, for instance, prescribe a Schedule 2, 3, 4 prescription drug to a patient. So a little bit of a higher bar in how the telemedicine was utilized at that point. Additionally, they allowed for temporary residents of Virginia to be able to obtain a written certification. So thus far, you had to be a permanent resident of Virginia in order to be eligible to receive a board registration and be issued a written certification by a practitioner. But in 2020, they expanded that to allow for a temporary resident. So maybe that's a snowbird who lives here part of the time. Maybe it's a college student who lives here part of the time throughout that calendar year while they're in school in Virginia. Additionally, they authorized each pharmaceutical processor to have some partial ownership of up to 5 cannabis dispensing facility permits in each health service area. So it's at this point that we went from 5 dispensing locations legally up to the 30 dispensing locations that patients can use today. Next slide, please. So in 2021, more legislation was introduced, and very notably, it authorizes the dispensing of botanical cannabis, another significant expansion to this program. Again, thus far, it had just been oils. Now we have botanical cannabis that can also be dispensed from these facilities. Previously, the Board of Medicine and the Board of Pharmacy were required to collaborate and develop a number of patients, a cap, if you will, on the number of patients that a practitioner could issue a written certification to at any given time. And that number had been established at 600 patients. The General Assembly removed that cap, and it is still to this day removed. And so a practitioner can issue really any number of written certifications to any volume of patients that they deem appropriate. They also eliminated the pharmacist's supervision of the cultivation and the production area of the pharmaceutical processors. So prior to this, a pharmacist had to supervise the entire pharmaceutical processor operation. That included the cultivation, the production, and the dispensing areas. Currently, the pharmacist's supervision is only required of the dispensing areas within that facility, and other qualified experts can oversee the cultivation and the production areas. The General Assembly also authorized advertising for the first time and directed the board to promulgate regulations on how that could be performed. And they expanded the allowance for telemedicine. And so it's a much more lenient expectation and requirements associated with the use of telemedicine that would ultimately lead to the issuance of a written certification for a patient. In 2022, the General Assembly removed the requirement for a patient, parent, or legal guardian to have to register with the Board of Pharmacy. So prior, a patient, parent, legal guardian had to register with the board in addition to getting a written certification from a practitioner before they could obtain the medical cannabis. In 2022, the registration requirement was removed from the code. They obviously still have to have a written certification from a practitioner, but they no longer have to register with the board. Now, it is optional. The code does recognize that if they want to obtain an optional registration from the board, they can do that. And we see occasionally people will seek an optional registration. Perhaps they have a legal custody issue or a work environment really wants them to have that additional layer of documentation for them to use medical cannabis. So there are a few reasons why someone may opt to obtain it. Occasionally, there is some reciprocity with certain states. So if you're in Northern Virginia as a patient, you want to cross into Washington, D.C. and use one of their dispensaries. D.C., I believe, does require you to have this optional registration from the Virginia Board of Pharmacy just to prove eligibility to obtain product from the DC market. They also allowed for a wholesale distribution of bulk cannabis, not just final products between the pharmaceutical processors, but the actual bulk cannabis product that can then be used to produce products at that second pharmaceutical processor. They talked about marketing in addition to some advertising, and they directed the board to promulgate regulations for how these pharmaceutical processors could use hydrocarbon-based solvents that were previously not allowed. And those solvents are oftentimes used to extract the cannabinoids from the plant. It's a little bit cheaper to use, as I understand it, the hydrocarbon solvents, and it can create a higher THC concentrated product as well. And I think is commonly used in this industry across the states. Next slide, please. So that brings us up to 2023. Once again, we had General Assembly pass legislation on this program. At this point, they have passed legislation that will transfer the regulatory oversight from the Virginia Board of Pharmacy over to a brand new state agency. It goes by the name Virginia Cannabis Control Authority. You may have seen articles in the media again on this. This transition will occur January 1, 2024. Additionally, the General Assembly removed the requirement for practitioners to register with the Board of Pharmacy. So up until July 1 of this past year, a practitioner also had to register with the board in order to issue a written certification. That is no longer the requirement. Any physician, nurse practitioner, or PA is qualified to issue a written certification to a patient recommending the use of medical cannabis. They also remove the requirement for a registered agent to truly obtain registration from the board. Now, there are some instances where they will still need to obtain registration. In essence, what the General Assembly created was a provision for a patient. If they know at the time that they are receiving a written certification from a practitioner that they have an inability to go to the dispensing location to obtain the product, and perhaps they want a family member or a caregiver of some sort to be their agent to go acquire the medical cannabis product for them, they can tell you as the practitioner this information. And if you deem it appropriate in your discretion and based on the medical circumstances that is being presented or that you're treating the patient for, if it seems appropriate that you want to include this individual's name on the written certification as this specific patient's registered agent or agent in this case, they will be recognized as serving in this capacity. That individual that is named as the patient's agent on the written certification does not actually have to obtain Board of Pharmacy registration. They can simply present the written certification to the dispensary. They will see, the dispensary will see that individual's name listed on the written certification. They'll provide government ID, proof of identity, and then they can obtain it on behalf of the patient. In the instance, though, where a patient may not know at the time that they are receiving a written certification from a practitioner that they desire to use an agent or have a need to use the agent, and so therefore that individual's name is not captured on the written certification, that person who is going to serve in that capacity as that patient's agent does need to obtain registration from the Board of Pharmacy. And so when they present to the dispensary, they will have the patient's written certification, they will have their board registration as a registered agent and show proof of identity, and then they will be able to obtain the product on behalf of that patient. So again, registered agent, there's two mechanisms now. They can either be listed on the patient's written certification, that does not require board registration, or if they're not listed on the patient's written certification, they do have to register with the board and have that registration to show to the dispensary. They also talked about product registration. So previously, the General Assembly allowed for, well, first off, let me back up. All products have to be registered by the Board of Pharmacy and approved before they can hit the market. We look for lab testing and ensure that everything has been passed successfully. We look at the names, the packaging associated with it to make sure that they are compliant with our laws and regulations. We then register that product and the dispensary can dispense. It is virtually impossible, as you can imagine, when you're dealing with a plant-based product, to produce an identical product in every crop yield. So the first crop yield may produce a certain medical cannabis product. We register it. The law previously allowed for up to a 10% deviation in those active ingredients before they had to register a new product again with us. So in 2023, the General Assembly expanded that 10% deviation to a 15% deviation. They also talked about some packaging and labeling changes, advertising and marketing changes. Notably, they also allowed for pharmaceutical processors to have an additional cultivation site permitted. Now, right now, there is no ability to obtain a permit as a cultivation site to support a pharmaceutical processor. Those regulations have to be promulgated, and they are being promulgated by the Cannabis Control Authority, theoretically to be in effect come January 1 by the time they take over regulatory oversight. So technically, a pharmaceutical processor cannot obtain a permit as a cultivation site quite yet. They will be able to do so that after January 1. These products, you may be aware, have to be reported to the prescription monitoring program. And just to make sure we're all on the same page, the PMP, as you probably know, is a state-based database of information. So every pharmacy that dispenses a drug in schedules 2, 3, 4, and 5, every physician that dispenses these drugs has to report those dispensations to the state database, the PMP. Medical cannabis is reported to the PMP as well. So even if you're not someone who has experience issuing written certifications, if you query a specific patient in the PMP, you may very well see that they have attained medical cannabis based on a written certification issued to them by a different practitioner. So just be aware, we're going to talk about some possible drug interactions and things of that nature. The legislation specifically in 2023 on this particular subject requires the product, when it's reported to the PMP, to be reported based on the primary cannabinoid in that product, so that it's a little bit clearer to everyone involved what exactly this medical cannabis product is primarily. So the cannabinoid in greatest concentration, for instance, will be considered the primary cannabinoid, and that name will go directly into the PMP. Next slide, please. So based on all this legislation, generally speaking, it directed the Virginia Board of Pharmacy to promulgate regulations to provide and flesh out the details for how those laws could be complied with or how they were going to be implemented. And as you can see, every year there has been great interest in this area, and legislation has been approved by the General Assembly each year, and therefore there have been regulations promulgated every year by the Virginia Board of Pharmacy. Where we are currently is we have some emergency regulations that just completed the administrative review process, and they will go into effect August 16th of 2023. As I alluded to earlier, any laws that were passed in 2023 that necessitate regulation, either through new regulation or the amending of existing regulation, is going to be performed by this new Cannabis Control Authority. The Virginia Board of Pharmacy simply does not have enough time left in the duration of its oversight to promulgate regulations on these subjects and have them in effect before we transition our oversight over to the Cannabis Control Authority come January 1. But we have been working very, very closely with staff from the CCA, this new agency, and meeting with them on a weekly basis. We have staff members here that are meeting with them on a weekly basis, and we are working very collaboratively to ensure that they know what needs to be amended and how Board of Pharmacy may have considered amending those based on our past experience in regulating this subject. And so again, the goal is to support them so that we have a seamless transition and that everything is in effect come January 1 of 2024. Next slide, please. The way this is going to work, ideally, the VCCA will have its regulations in place and ready to go come January 1. At the December Board of Pharmacy full board meeting, our Board of Pharmacy will rescind all of its regulations and any guidance documents it has related to medical cannabis to take effect just prior to January 1. So that again, legally, everything will switch over come January 1 over to the Virginia Cannabis Control Authority. Next slide, please. So very briefly, in case you're interested, we'll talk a little bit about fee structure. The fees associated under CCA, the Virginia Cannabis Control Authority, may look a little different. They are a new state agency that is modeled differently than the Department of Health Professions, which is an umbrella agency of 13 health regulatory boards. So their expenditures and revenue needs may be very different from our existing state agency. Right now, a pharmaceutical processor application is $10,000. The actual permit, if awarded a pharmaceutical permit, is $60,000, and there is an annual renewal payment of $10,000. A cannabis dispensing facility pays an initial $5,000 application fee and an annual renewal fee of $1,500. Every medical cannabis product that has to be registered with the board, there's a nominal application fee of $25. And then if someone chooses to get one of these optional registrations, the patient parent, the legal guardian, the registered agent, you can see the either $25 or $50 initial application fee along with an annual renewal fee. Next slide, please. So this is a map of all of our current pharmaceutical processor and cannabis dispensing facilities presently operating in the Commonwealth. So again, we have 4 pharmaceutical processors currently operating. They are Delitzo and Manassas, Dharma and Abingdon, Greenleaf Medical of Virginia in Richmond, and Columbia Care, Eastern Virginia in Portsmouth. These 4 processors have each about 3 to 4 cannabis dispensing facilities associated with them in their respective health service areas. Those dispensing locations are Sterling, Alexandria, Arlington, Fairfax, Virginia Beach, Glen Allen, Richmond, Williamsburg, Hampton, Norfolk, Suffolk, Colonial Heights, Bristol, Danville, and Christiansburg. So we have 17 cannabis dispensing facilities currently in operation to support the 4 pharmaceutical processors. So currently right now, there are 21 locations where patients may obtain medical cannabis throughout the Commonwealth. Oh, I'm sorry. I did leave off 2 locations for the dispensing facilities. We have one in Lynchburg and Salem as well. Next slide, please. So moving into some data, this is just a snapshot of the number of patient registrations that the board issued each calendar year during the implementation of this program. So in 2018, you'll recall there was just an affirmative defense. We did not have pharmaceutical processors operating. There was no product to be obtained. So at that point, the board had only issued about just over 200 patient registrations. In 2019, the board issued about 1,300 patient registrations. It wasn't until the middle of 2020 that we had our first medical cannabis products actually available in this market space. So we did see a slight increase. The board issued about 7,100 patient registrations that calendar year. In 2021, we now have 4 pharmaceutical processors fully in operation with steady medical cannabis products hitting the market. So you can see there was quite a spike in the number of registrations issued to patients, parents, and guardians that year by the board. We had over 33,000 registrations we issued in that calendar year of 2021. In 2022, you can see that that number continued to grow. In the first 6 months, we'd issued 24,000 registrations, clearly on track to exceed the 33,000 from the year before. However, it was in 2022 that the General Assembly removed the requirement for patient, parent, legal guardian to obtain a registration for the board. So we saw a sharp decline starting as of July 1, 2022. And then just in the first 6 months of this year, or 7 months, well, just over 6 months of this year, the board has only issued about 1,400 new patient, parent, legal guardian registrations. Next slide, please. So currently we have just over 12,000 patients who are registered with the Board of Pharmacy, 59 parents, legal guardians, 131 registered agents. We have 900 practitioners registered with the board who are practicing here in Virginia. And we have 148 practitioners registered with the board who have a practice address outside of Virginia. And that is permissible as long as they hold a license to practice medicine and had this board registration. Again, as of July 1, even physicians or practitioners are no longer required to obtain board registration. But this data is of July 11th. Cumulatively, the Board of Pharmacy has approved over 3,100 medical cannabis products since the inception of this program. Next slide, please. So if you are a patient, what required documentation do you have to have in order to obtain medical cannabis? Well, you must have a current written certification issued to you from a physician, nurse practitioner, or PA. A written certification is valid for no more than 12 months, very similar to a prescription. So it does have to be reissued on an annual basis. The patient also has to have a government issued ID to show proof of identity and to verify that residency or temporary residency in Virginia. Those are really the only two required documents that they have to have in obtaining their medical cannabis. They can have the optional board issued registration, but again, that's optional currently, no longer required. Next slide, please. So this slide is going to indicate the patients, the number of patients who were dispensed medical cannabis each month between 2021 and June of 2023. And you can see that there has been a 9-fold increase during this time frame. So from January, during January 2021, there were over 3,300 patients that month who received medical cannabis. As of June 2023, there were over 29,000 patients who received medical cannabis products that month. So a sharp increase over this time period as interest and education on this program has grown. Next slide, please. So this is monthly dispensations of medical cannabis products that were dispensed between 2021 and June of 2023. So you can again see the number of products that are being dispensed during this time frame, sharp increase. We've seen 11-fold increase between January of 2021, where in that month, only 18,000 medical cannabis products were dispensed, taking you up to June of 2023, where during that month, over 206,000 medical cannabis products were dispensed. So giving you some calendar stats, during 2021, there were over 561,000 medical cannabis products dispensed during that calendar year. 1.4 million products were dispensed during 2022. And thus far, as of July 20th in 2023, we already have had over 1 million products dispensed. So probably projecting somewhere close to 2 million products being dispensed during the calendar year of 2023. Next slide, please. There was a slide in there that is a little bit older in data point. We're having a little glitch in our database to be able to calculate the number of practitioners. But just to give you some frame and context, between January 2021 and August of 2022, we saw the number of prescribers who are associated with dispensed products more than double. In January of 2021, there were 200 practitioners associated with the dispensed cannabis products at that point. In August of 2022, there were over 440 practitioners associated with those cannabis products. So we are seeing an increase in the number of practitioners entering into this space. And then if we could go to slide on page 19, this is just also speaking to the practitioners, the increase in practitioners. So yes, while there has been an increase in the number of practitioners associated with medical cannabis, it's important to realize that this data is somewhat skewed. So between January 2022 and May of 2022, we had 453 practitioners associated with over 415,000 medical cannabis dispensations. So on average, that's 184 dispensations per practitioner. However, if we look at the data closer, we realize that half of the practitioners are associated with either 20 or fewer medical cannabis dispensations per month. That means 66% of the dispensations are attributable to only 5% of our practitioners. And each of these practitioners, each of these 23 practitioners, have over 1,000 dispensations per month. And 9 of those 23, or about 39%, are out-of-state practitioners. So in essence, we have a small number of practitioners who are issuing a lot of written certifications. And maybe that's not that unheard of. This is somewhat of a unique market and area of expertise. And in treating patients, it somewhat makes sense that you may have practitioners who are very comfortable in this space. It's their niche. They are a go-to for patients who desire to be treated with medical cannabis for their medical conditions. And we have a number of practitioners who might have at the time, issued a board registration for this purpose, and they may be issuing the occasional written certification, but they're not routinely doing a lot of it. So again, this data is just suggestive that we have a small number of practitioners who are issuing probably the majority of our written certifications. Next slide, please. So this will give you a snapshot of the different types of cannabis product formulations that the board has approved and that are available out there on the market. You can see we have quite the variety of nasal spray, chewable edibles, suppositories, topical gels and lotions, oral oils, and then we have oils that are used in vaped inhalations, wax concentrates, bubble hash concentrates, the occasional tablet, capsule, lozenge, and then of course, botanical cannabis. The 2 columns show the combined THC, THCA ranges for these approved products. And then the last column contains the combined CBD, CBDA range for these approved products. And you can see there's great diversity in specifically the THC, THCA concentrations. It is important to realize that THC concentration in the plant is just naturally higher now than it was years ago. In about 1995, research indicates that a marijuana joint or cigarette had about 4% THC. In 2018, a marijuana joint or cigarette has had about 16% THC. So we are seeing a natural increase of THC concentration in the plant alone. With respect to the products, the botanical cannabis products that are approved by the board, the majority of these products have a THC amount between 13 and 28%, and a CBD amount of less than 1%. So just to call out some potential outliers in this chart as well, for the inhalant products that are vaped, you'll see in the chart there's a 0.25% total THC product. But this is definitely an outlier. 99% of the products that are inhaled vaped have a much greater total THC concentration, with the majority falling between 30 and 80%. For edibles, the majority of the products have both a THC and CBD content of less than 1%. Since the July 1st code change, removing the required 5 milligram minimum of THCA or CBD in all of the concentrated products, there's been a significant reduction in the amount of these types of products. Additionally, since September 1st of 2021, 623 botanical products have been approved. So clearly there is a lot of popularity in the use of the botanical cannabis products as well. Next slide, please. So this is just for informational purposes. Here are a few guidance documents that the Board of Pharmacy has adopted relevant to the medical cannabis program. I'll let you peruse them with these hyperlinks as on your own as you're interested. One that I do want to call out specifically is guidance document 110-32. This is cannabis potential drug interactions, and it became effective in August of 2022. Next slide, please. So here's a excerpt, a screenshot of guidance document 110-32. And regardless of whether you are interested in potentially issuing written certifications to patients for recommending the use of medical cannabis or not. As a practitioner, you are likely going to see on a PMP report that your patient may be using medical cannabis. You may be prescribing or managing drug therapy with FDA-approved prescription drugs that could be interacting with the medical cannabis. So it is very important to pull those PMP reports on your patients, ask the pertinent questions, because there are legitimate drug-drug interactions, specifically with the cytochrome P450 enzyme family. And we've tried to highlight some of these from an educational standpoint in this guidance document. I will specifically call out that there is one level 1 interaction of very high risk. It's with warfarin. It is a CYP2C9 inhibition effect. And so therefore, use of cannabis, well, specifically, I think the studies revolve around CBD, but you may have an increased INR with concomitant use of CBD, resulting in GI bleeding. And so therefore, you do need to monitor INR closely for any warfarin adjustments and avoid this combination if possible. You can also see that there are some level 2 high risk interactions with buprenorphine, tacrolimus. Again, you may need to make some adjustments in those 2 prescribed drugs based on concomitant use. There are additionally some level 3 interactions of medium risk to be aware of as well. But again, I would encourage you to pull up this guidance document 110-32, which can be found on the Virginia Board of Pharmacy's website. Regardless of whether you, again, have an active role in the medical cannabis program or not, you need to be aware that your patients may very well be using these drugs with their FDA ARCs only drugs, and that interactions may exist. Next slide, please. This is just really an FYI. There are 2 additional guidance documents coming that are under administrative review, but they are mostly related to the operation of a pharmaceutical processor. Next slide, please. Very briefly, going to go through some miscellaneous information. The board does require an FBI criminal background check on material owners of these dispensing facilities, as well as the pharmaceutical processors. Generally, what happens is a practitioner will recommend the use of medical cannabis, but then the patient will work very closely and collaboratively with the pharmacist at the dispensing location to sort of assess and determine what is the ideal or optimal product formulation and dosage for that patient's medical condition. All of these products do have to be tested by independent labs for content and quality, and they have to be labeled accurately with an assigned expiration date. Specifically, they have to pass microbiological, mycotoxin, heavy metal, pesticide chemical residue, residual solvent, and an active ingredient analysis testing. They also can only be assigned a 6-month expiration date unless they have stability data to justify a longer expiration date. Next slide, please. The lab results are available to patients as well as to practitioners upon request. So you can obtain those directly from the pharmaceutical processors or cannabis dispensing facilities. Facilities are inspected by the Board of Pharmacy, both prior to going into operation, as well as routine unannounced inspections that are performed to assess compliance. Any disciplinary action that may result either based on inspections or the result of patient complaints and investigations can be accessed on the Board of Pharmacy's website through the license lookup feature, just like any other disciplinary action that would be taken against any one of our licensees. Again, dispensations are reported to the PMP, and the board is acquiring a new licensing software. So if you are someone, a practitioner who does issue written certifications or may begin being interested in this, please be aware that we are going to be pushing out additional information, communication on the subject of a new licensing software system. Right now, the written certification is a paper form that we provide to you as a practitioner, but we are moving to a digital process. So through this platform, you would register as a practitioner. You would then issue this electronic written certification to the patient Through this platform, the patient could submit an application if they so chose for that optional registration with the board. At the end of the day, they're going to have a digital written certification on their phone that they can take to the dispensary, and then the dispensary would barcode scan to determine validity of that written certification. So we are moving to an electronic mechanism, hopefully implemented in the next month. And so we've started communicating out on that. Additional communications will be forthcoming. Next slide, please. In the context of stigma, this is a subject where I think it's focused on the lack of research that exists in this space. So when you look at information from the National Academies of Science, Engineering, and Medicine, I think they feel reasonably comfortable with the studies being supportive of the treatment of spasticity associated with multiple sclerosis, chemo-induced nausea, certain epileptic syndromes, and certain types of pain. Beyond that, the research is a little unclear, and it's really unknown at this point how effective medical cannabis is to treat some of these other medical conditions. It's not to say that it's not effective. The problem is we just don't have a whole lot of comprehensive research to really grab hold to. We do see some bills getting introduced and considered at the federal level to make it a little bit easier for researchers to research with a Schedule I product. Again, marijuana being a Schedule I at the federal level. That is somewhat of a barrier for and challenge for researchers to be able to research this subject. But we are all navigating this across the country. We have about 38 plus states who have legalized medical cannabis in some form or fashion. And hopefully we will have additional robust studies to help guide proper treatment with the use of the product. Next slide, please. As a practitioner, I think you might just want to be aware of some of the learned lessons in other states. Clearly, this product may have psychoactive components to it, depending on the level of THC concentration within the product they use. There could be impairment. We may have issues with driving. Hyperemesis is an issue that we are seeing across the country in emergency departments as a result of sort of chronic use of medical cannabis. Cannabis use disorder. You can get addicted to cannabis. I don't know that everyone knows that, but this is a substance that through chronic use can be addictive, just like many other drugs. And so you may have patients presenting with some of those side effects of addiction, the disturbances of sleep. Maybe it's impacting their mental health in some capacity as associated with the chronic use of the cannabis. There are legitimate drug interactions you need to be aware of. We are seeing, unfortunately, maybe not so much in the medical cannabis market, but in the hemp market, unintentional overdoses of children. So packaging is very important to ensure that we are not enticing children to think that this is candy or not a medicine. And so therefore be very aware as you're treating patients about the possibility of accidental ingestion. And then of course, you probably heard several years ago, all the concerns and information about vitamin E acetate as a carrier oil and being associated with lung injury. So patient education is needed, public education is needed as this program continues to grow in usage. There are issues that we need to be aware of, and we need to continue to educate the public and our patients on. Next slide, please. Very briefly, again, I think we've talked about the transition plan. The one thing maybe we haven't talked about is the current RFA, the request for application for that 5th pharmaceutical processor permit. So there were some legal challenges. The board did prevail in several court orders. And where we are right now is the Board of Pharmacy will consider the current status of the request for application at its September 26th board meeting. It is very possible they may consider closing that request for application, recognizing that they will not have enough time to issue a conditional approval to a facility prior to the transition over to the Cannabis Control Authority. And it may be more appropriate for the CCA to issue a new RFA come January 1. So we only have a few minutes left. I was hoping we'd have a little bit more, but I'm happy to try to answer any of the questions that have come in on the chat.
Thank you so much, Caroline, for this wonderfully informative session. I think many of us have heard either nothing, a little bit, or a lot, and I think you covered a lot of the basics throughout the conversation. I can go through and ask some of the questions that were posted in the chat, but I did want to mention that all of the resources, the links, this recorded session, as well as the presentation, and like I said, the resource links will all be posted online on the Office of Continuing Professional Development website. So that's usually done within about a week. Let me get to some of these chat questions. Can someone actually overdose from cannabis? And you did mention that that is a possibility, particularly seen with children, for things that may be perceived as candy or things like that.
Right. As I understand it, I do not believe that there's any research to support fatal overdoses. So I don't think that is necessarily a concern, but certainly you can have too much ingestion of a THC concentrated product and then experience the side effects associated with that. Children in particular may be more vulnerable to being able to respond appropriately and come out of some of those side effects associated with high THC concentrated products.
Excellent, very helpful. I may have missed it, but do you have data about the medical diagnostic categories or conditions for which clinicians are recommending cannabis use for their patients? And you did mention that also on one of your more recent slides as well, though those which are the conditions which are supported within the literature and with the research, and then there are a lot more potential conditions, but they just haven't shown the research yet.
Correct. And we do not collect the data on why it is being issued, what medical condition. So we really can't say what the level of prevalence is for the medical conditions being assigned to the written certifications. But of course, the law would allow it to be issued for any medical condition that the practitioner deems appropriate.
Excellent. What are the majority of the healthcare providers' credentials, MDDO, NP, or PA, others?
Yeah, I don't have that data either. We just know the number of registered practitioners at this point. We can try maybe to tease that out in future presentations, but legally, it must be a physician, a nurse prac, or a PA. Those are the only ones who can prescribe, or excuse me, recommend for this purpose.
And do you have any other recommendations for getting past the barriers to studying medical cannabis at this point?
I don't. I do think it's probably going to require federal legislation. It is the DEA at the federal level who places the drug into Schedule 1. Therefore, until the federal law is adjusted, perhaps to create a little bit more leniency to allow for research of a Schedule 1 product, or either federally, it could be placed in a separate class to make it a little bit easier. There have been lots of different strategic options proposed. We'll have to wait and see what Congress does with this issue.
Okay. And are there chemicals associated with the pharmaceutical processing of medical cannabis?
Say that one more time.
Are there chemicals associated with the pharmaceutical processing of medical cannabis?
Well, there are solvents
Okay.
used in the extraction process often. And so as part of their testing process, they do have to do a residual solvent testing of the product before it can be released. They also have to test for pesticide, chemical residue, heavy metal, mycotoxin, microbiological. Hopefully that is on point with the question.
And also, I think that helped to answer it. Thank you. Can you speak to the cost of these products?
Really can't. We do not collect that data. Anecdotally, I am told that it can be quite expensive. And it is a cash only business for the most part. Obviously, health insurance does not currently cover medical cannabis. So I really hesitate to even to throw out any numbers, but I do think it can be expensive depending on the type of formulation. certainly you could contact a pharmaceutical processor directly. You may even be able to obtain that kind of information on their websites.
And then one last question for the group at large. Why might a practitioner choose to become registered since it is optional? I know you spoke about.
So really, if I wasn't clear, let me try again. The practitioner doesn't have the option really of registering. There's really no registration for a practitioner any longer. It is the patient who has the option, the patient, parent, and guardian who have the options to obtain registration. Practitioners don't need to be registered with the board. They can simply issue the written certification as long as they are a doctor, PA, or nurse practitioner.
Excellent. One more question. Sorry, it just popped up. And I think I can answer this, but it says, just to clarify, can NPs and PAs prescribe, not just recommend, but you said that they can only recommend, there's no actual.
Yeah, no one can legally prescribe this product since it's still illegal federally. You can't issue a valid prescription for this purpose. So the best anyone can do is to recommend them use on the written certification form. And that's a model that's used throughout the country.
And the written certification form, one more time to clarify what that entails, because it's not on a regular prescription form.
Yeah, that is a defined form that is provided by the Board of Pharmacy. And it's a paper form at this point in time. So if you are a practitioner who wants to issue a written certification, you need to contact the board. We'll provide you with a link to this paper document that you can use with your patients. In the near future, it will be an electronic document that you would register on our platform, have access to, and issue electronically to your patient.
Wonderful. Thank you so much. So anybody who can stay and has extra questions, please feel free to do so. Anybody who has to run to another meeting, etc., please carry on with your day. And I hope you all have a wonderful day. Caroline can stay on the line for just a few more minutes, and then also has her contact information. Thank you. Have a great day.
Thank you all.